Hello. My name is Brendan Rand. Hope you all are doing good. I appreciate you for watching my video today. Today I'm going to be making a presentation on why we should not use victim impact statements in a sentencing phase of a criminal trial. There's many reasons why we should not, but I'll absolutely respect the emotional suffering and pain that is caused by victims that families go through. I believe that including these statements in court, especially during sentencing, undermines the fairness of the trial. It creates emotional bias and violates the constitutional due process of the rights accused. I'm going to be pulling from two big sources. One is Chief 2019, the pros and cons of victim impact statements, leaning more on the cons. And I'm going to be pulling from justice.gov 2023. I'll be having these linked in the description and pulled from the end. But I do agree with this statement from earlier. The use of victim impact statements unduly and negatively impacts the rights of the accused to a fair trial, as it is a direct violation of due process rights. To support my position, I'll respond to 5 questions that was mentioned earlier, providing yes and no. Number 1, is the use of videos from birth to adulthood necessary? I'd say no. Videos that show the victim's life from birth to adulthood, with testimonies from surrounding friends, teachers, and other people they may be close to, that may not even be related, don't belong in a courtroom. These types of visual presentations go far beyond describing the harm caused by the crime. They are designed to pull off jurors' emotions and create sympathy, not provide legal facts. This can lead to sentencing decisions based on emotions rather than the law, which goes against the purpose of a fair trial. We all want fairness. Why bring people that may not even resonate or understand the impact that you have had, which may be real, but you have to understand we need to see all areas of it. Number 2, should only family be allowed to contribute? I'd say if there will be a victim impact statement, VIS, then I'd say that yes, they should be the only ones. They should only strictly be limited to immediate family members. Allowing friends, coworkers, teachers, or even close relatives that are not in your immediate family members to speak open doors. These show excessive emotions influence. A courtroom is not a place for a long list of personal reflections. You can look at their life behind. The more people who speak, the harder it becomes to separate justice from emotional storytelling. And we know how emotions come out when you're on stage and you feel the victim feels the real pain that has been caused, but not to say that all the time that's false, because most of the time it is real pain and turmoil they're facing on the spot. You have to weigh the other side of it. Some of it is false, some of it is not genuine, and we can get an inaccurate sentence based off of that, and especially if you have unnecessary close ones giving their part as well that were not your immediate family. So number 3, can victims read poetry or book passages, also videos? I'd also say no. Expressing harm through poetry, scripture, and other symbolic languages might be helpful in the healing process, but it has no place in the sentencing hearing. These types of emotional expressions don't help a judge or jury make a fair decision. Instead, they can distort the focus and create an emotional atmosphere where the legal principles of fairness and consistency gets lost. This is why we always see victims expressing what happened, but it won't be accurate, or we'll get an unfair view from the outside, and it could be a false reading. So I'd say number 4, should the judge give strict jury restrictions about VISs? In this case, yes. Judges should give clear instructions on how they interpret the weight of the VIS being presented. But the reality is, this doesn't always happen, close to not much. Even when instructions are given, they may not be strong or specific enough. Jurors can easily be swayed by emotions. That's not fair sentencing, in my opinion, especially after hearing a powerful, heartbreaking statement without firm guidance that emotionally can outweigh facts and evidence that actually happened. Number 5, should the defense be allowed to rebuke the VIS? I'd say yes, once again. The defense have the opportunity to respond, but in most cases, they don't get a fair chance. Like I said, this all goes up together, why we shouldn't have them. They may be valid emotions and feelings, but we're looking at it from a point of law, from the victim standpoint, which you would think it's the real thing. But the VIS is often presented without cross-examination or verification in the background process. If the defense tries to challenge the victim's emotional claim, they risk losing insensitive information in front of the jury. This creates an unfair situation where the prosecution presents powerful emotional testimony and the defense is left with no way to respond. To conclude, I believe victim impact statements should no longer be used in the sentencing phase of a trial. These statements can create emotional bias, weaken due process protections, and shift the courtroom away from the objective justice. Victims should be heard and supported, but not always in the way that unfairly impacts the right of the accused. The legal system isn't perfect, but it has to be fair and consistent for everyone, no matter what that may look like for each and every person. But we're going to try and make it as a universal thing. If we allow emotions to dictate sentencing, we open the door to unequal outcomes and potentially irreversible mistakes, i.e., incorrect sentencing. But I want to appreciate you for listening to my take on this. Thank you.